Welcome to Family Court Services Orientation and Mediation. I'm Judge Mary Greenwood, and I'm here to welcome you on behalf of the Santa Clara County Superior Court and to do a brief introduction to this process. Mediation is a problem-solving process in which professionals from Family Court Services will work with both of you to develop a plan for the custody and visitation of your children that's in the best interests of your children. There are two components to it. The first is legal custody. Legal custody includes the right to make decisions about the child's residence, health, education, and welfare. And it can be either joint custody or sole custody. Joint custody means that both parents have the right to make these decisions. Sole custody means that one parent has the exclusive right to make these decisions. Physical custody is the other component of custody, and this also can be either joint or sole custody. Joint physical custody means that both parents share significant periods of physical custody of the children that assures frequent and continuing contact with both parents. It does not mean that the time will necessarily be equal or 50-50. Sole physical custody means that one parent provides primary supervision and physical control of the child or children. The other parent still has visitation rights. There are special rules that relate to cases in which there is a domestic violence protective order. Family Code Section 3044 states that it's presumed that a parent who is found to have committed domestic violence cannot be the custodial parent of children. Often the court will order visitation in ways that will keep your children safe, even if you cannot be the custodial parent. And the presumption can be overcome in certain kinds of ways. But it is very important that you understand this provision of the law. The mediation process will be conducted in a different way if there is a restraining order in place as well. The parties will be physically separated, and the mediator will go from person to person during that process. Through mediation, your goal should be to develop a plan that is practical, that provides consistency and stability for your children, and that makes a healthy relationship with both parents possible. Your approach or your mindset is very important as you enter into mediation. It's important for you to know that mediation is not about winning or losing. It's about reaching a solution in your child's best interests. You are no longer partners, but you are still parents, and you are the important adults in your children's lives. Your child will look to you to see how you solve this hard problem. They need to see that although things will not be the same, they will eventually be okay, and you are the ones who model that by reaching a plan together. You want to come to mediation with ideas, you want to be open to ideas, and you want to be flexible. You want, above all, to work towards your children's best interests. Children should not be forced to choose between you. They love you both. They have a right to a healthy relationship with both of you and each of you. You want to do the hard work now of reaching an agreement so that you avoid constantly returning to court and being in conflict with one another. And finally, most people find that they are happier if they reach an agreement for their children together about custody and timeshare. We wish you the best for you and your children as you work through the process of mediation together. And now turn you over to the professionals at Family Court Services. Thank you very much on behalf of the court.
Family Court Services, California Superior Court, County of Santa Clara welcomes you to Orientation to Mediation, Part 1. What is child custody mediation? Mediation is guided decision-making to help parents develop agreements about how they will care for their children after separation. Do I have to go to mediation? Mediation is required in California whenever there is a dispute about child custody or visitation. Why would I want mediation? It's your opportunity to resolve disagreements about parenting with the help of a specially trained mental health worker at no cost. What if we already have an agreement? If both parents completely agree to a parenting plan, then there is no need for custody mediation. To make your plan a court order, you must provide a written agreement to the court for approval. The Self-Help Center may be able to help by providing the proper forms. What is discussed in mediation? a parenting plan that is in the best interests of your children. What is not discussed in mediation? Child support, spousal support, property, and other monetary disputes. What may a parenting plan include? Your parenting plan may include a timeshare schedule, a school year schedule, a summer schedule. Your parenting plan may designate how you will share holidays and birthdays, vacations, transportation and exchanges of your children, phone calls, and extracurricular activities. Parenting plan considerations. Some of the things you will want to take into account when developing your parenting plan are the age and emotional stage and development of each child. You want to plan for changes as your children grow. Be sure to let your children know about schedule changes. Take into consideration your children's special needs. Make sure your children know when they will see the other parent. Parenting time for infants. Short, frequent periods of parenting time provide the child time to bond with each parent without disrupting nursing and time to learn, trust, with the stability of a primary home. For example, father shall have the care of the child every Sunday, Tuesday, and Thursday from 5 p.m. to 7 p.m. Father shall also have the care of the child every Monday and Wednesday from 8 a.m. to 10 a.m. Parenting time for toddlers. Toddlers are learning that you still exist even when you're out of sight. They are okay with more time apart from each parent. Example, mother shall have the care of the child every Monday and Wednesday from 3 p.m. until 7 p.m. Additionally, mother shall have the care of the child every first and third Saturday from 9 a.m. until Sunday 4 p.m. Parenting time for school-age children. School-age children can understand how to read a calendar and like to know what to expect. Consider a family calendar with days at each parent's home and the child's dental appointments, medical appointments, sports dates, etc. Example, the father shall have the care of the child every Monday from 8 a.m. until Wednesday at 8 a.m. The mother shall have the care of the child every Wednesday from 8 a.m. until Friday at 8 a.m. The parent shall alternate weekends from Friday at 8 a.m. until Monday at 8 a.m. Parenting time for teens. Teens are developing their independence. They appreciate being near their friends and tend to prefer less transitions between homes. Example, the parents shall alternate the care of the child weekly from Sunday at 6 p.m. to the following Sunday at 6 p.m. Legal custody. Legal custody includes the right to make decisions about a child's residence, health, education, and welfare. Legal custody is either joint or sole. Joint legal custody means that both parents have the right to make decisions. Sole legal custody means that one parent has the exclusive right to make decisions. Physical custody. Physical custody is either joint or sole. Joint physical custody means that both parents share significant periods of physical custody that assures frequent and continuing contact with both parents. It does not necessarily mean equal time share. Sole physical custody, it means one parent provides primary residence and physical control of the child. The other parent still retains rights. Custody if there is domestic violence. If an act of domestic violence is committed by a parent, the court presumes that they should not have custody of the children. This presumption may be challenged at a court hearing regarding custody of your children. Domestic violence orders are handled outside of the mediation process. See Family Code 3044 for more information. Special rules at family court services when there is domestic violence. Restraining orders are to be obeyed at all times. The restrained party must wait in a different waiting area separate from the protected party. Mediation will be conducted with separate sessions. A support person may be present during the mediation session when there is a restraining order in effect. If you feel unsafe at any time, The mediator will end the joint session and interview both parents separately. Will the mediator tell the court what is best for my child? No, mediation is confidential. The mediator will not testify to the court about anything that happened or was talked about in mediation. The mediator will remain neutral. He or she will not take either side. The mediator will not give the judge any recommendations. Mediation in Santa Clara County is non-recommending, which means if no agreement is reached, you'll be referred back to court to resolve your disagreements. Limitations to confidentiality. Mediators may recommend that an attorney be appointed for the child. Mediators are required to report to the local child protection agency or law enforcement any suspected or alleged child abuse, as well as when someone appears to be harmful to themselves or others, for example, threats to kill themselves or others. Mediation process. Sessions will be held together if no domestic violence is alleged. Sessions will be held separately if domestic violence is alleged. Generally, the participants only include the legal parents and the mediator. Joint parties are expected to attend mediation. Minors' counsel attends the mediation sessions unless he or she waives their participation. Mediation guidelines. Do focus on your child's best interests. Come prepared with an open mind. Prepare to discuss several possible options. Please don't focus on the other parent. Reject a proposal without consideration, or let others make decisions for you. During mediation, each parent will present their proposal for child sharing and custody. Parents will negotiate and compromise to reach an agreement. The mediator remains neutral, does not represent either side, and helps both parties reach an agreement. When represented by an attorney, if either or both parents are represented by an attorney, the agreement will also be submitted to the attorneys for review. Who are your mediators? Your mediators at Family Court Services all possess a master's degree or higher in a behavioral science such as psychology, social work, marriage, family, or child counseling. They also have a minimum of 5 years' experience, knowledge of the court system, and community resources. Children in mediation. Mediators may use their discretion in deciding if your children will be interviewed. Mediators are trained to work sensitively in these matters. Children are not asked to choose sides or to choose between parents at any time. Mediator limitations. Mediators may not discuss your case with anyone, including judicial officers or attorneys. Mediators cannot give legal advice, discuss child support, spousal support, or division of property. They also may not make any recommendations to the court. Frequently asked questions. How do I get my appointment? Family Court Services will send a notice of your mediation appointment after both parties have completed orientation and intake forms. When are appointments? Appointments are scheduled Monday through Friday for 2 hours at 9 a.m. and 9:30 or 1:30 and 2. What if someone fails to attend? Mediation will be rescheduled one time. 2 no-shows will result in a referral back to court. No-shows and late cancellations will have to pay a fee. How much does it cost? It is free if you appear as scheduled. What if someone is late? Mediation cannot start until both parties arrive. A late arrival of 15 minutes may result in a reschedule of the appointment. More frequently asked questions. Who should attend? Both parents attend. Do not bring children to the first mediation. Can I reschedule? Only in an emergency. Please call 408-534-5760 to reschedule your appointment at least 48 hours in advance. Where is mediation held? Mediation sessions are held in the new Family Justice Center Courthouse at 201 North 1st Street, 95113 in downtown San Jose. End of Part 1.